You are welcome to this presentation. My name is Akeem Olajide Bello. I'm an associate professor at the Faculty of Law, University of Lagos. This is a continuation of the presentation on parties to an offense. We have looked at the various scenarios under sections 7A, B, C, and D when a person can be a party to an offense. We want to continue today by looking at offenses committed in prosecution of an unlawful purpose under the provisions of Section 8 of the Criminal Code. The provision of Section 8 of the Criminal Code imposes criminal liability on persons involved in a joint criminal enterprise for any offense committed in prosecution of their common purpose. Now, what that provision deals with is a situation in which you have different offenders who are involved in a joint criminal enterprise to commit an offense. And in the course of committing that offense, something occurred which is a probable consequence of carrying out their joint criminal enterprise. Now, each of the offender will be liable for that which is a probable consequence of their joint criminal enterprise. In Onyenye against the state, 2012, 15 Nigerian Weekly Law Report, Part 1324, the Supreme Court held that the test of liability for offenses committed in prosecution of common intention is whether the act complained of is a probable consequence of the prosecution of their joint intention to carry out an unlawful act. And it is irrelevant who held the gun, because once one of the robbers was in possession of a gun, his hand is deemed to be the hand of all of them. Now, that will cover a situation in which armed robbers set out to go and rob. Maybe the armed robbers are 4 or 5, and one of them carried a gun in prosecution of their common intention to go out to commit armed robbery. If in the course of committing the armed robbery, the one who carried the gun shoots and kills one of the victims. Now, the killing of the victim in this instance is a probable consequence of their carrying out their common intention of committing the offense of armed robbery. So the other robbers who did not carry the gun will also be liable for the death of the victim, because the death of the victim is a probable consequence of the prosecution of their joint intention to carry out an unlawful act. The unlawful act that they have agreed to carry out in this instance is the offense of armed robbery. So I always tell students when we are looking at this provision that this provision does not create an offense. This provision only creates a means of holding offenders liable for the consequence, for a probable consequence of their carrying out their common intention. It does not create an offense. Section 8 does not create an offense. It is a provision that enables the court to hold all the offenders liable for a probable consequence of the prosecution of their joint criminal intention. So it's always important to bear that in mind. Where a common intention to use violence exists and death results, all are liable for murder. See the case of Ubero at the state, 2005, 5 NWLR, part 919 at page 644. And the case of Oya Heri against the state, 2015, 15 Nigerian Weekly Law Report, part 947 at page 159. So where there is a common intention to use violence to commit an offense, and death results from the commission of that offense, all the offenders are liable for murder. Before a person is held liable for offenses committed in prosecution of a common purpose, the following essential requirements must be met. 1, there must be 2 or more persons before these provisions can apply. See the case of Idiok and the state, 2006, 12 NWLR, part 993, page 1. And the case of Atiku against the state, 2010, 9 Nigerian Weekly Law Report, part 119 at page 241. Okay, so one of the essential conditions for the application of Section 8 of the Criminal Code is that there must be 2 or more persons involved. So once there are 2 or more persons involved, then all of them will be liable for the probable consequence of carrying out their joint criminal enterprise. The second requirement is that there must be evidence of common intention to prosecute an unlawful purpose. There must be evidence of common intention to prosecute an unlawful purpose by an express agreement between the parties, or more commonly by inference from the facts of the case. Now, the evidence of common intention to prosecute an unlawful purpose may be from an express agreement. If there is evidence of an express agreement between the parties, there is an evidence of a common intention to prosecute an unlawful purpose by express agreement between the parties, then that will suffice. But more commonly, the evidence is usually by inference from the facts of the case. Like if you see a situation in which 5 armed robbers attacked a set of victims, and one of the armed robbers is armed, or 2 of the armed robbers are armed, and in the course of prosecuting their common intention, 1 or 2 of the victims are killed. So the circumstances, from the circumstances of the case, the court can draw an inference that the possession of gun by 1 or more of the robbers is possession of gun by the others, and that the possession of gun evidences an intention to prosecute the unlawful purpose of armed robbery by all the offenders jointly. And the death that results, which is a probable consequence of their carrying out of their common intention, is all agreed to by all the offenders. Now, the evidence in each case should be scrutinized to see if a common intention can be inferred. So it is always a question of the court looking at the evidence and the circumstances of the case and finding out whether the court can infer a common intention. The case of Aram Bada is very instructive. 1944, 10 Waka, page 249. That was a case in which a driver of a lorry, the lorry had a left-hand drive. A left-hand drive. So the driver of the lorry was, in the lorry with a companion who was sitting in the passenger side. So the driver of the lorry drove the lorry on the other side of the road, and there was a cyclist that was coming towards the lorry. The passenger of the driver reached out from the window and struck the cyclist with a stick, and the cyclist fell and was killed by the lorry. So the 2 of them were charged for the offense of manslaughter, and the two of them were initially convicted. But on appeal, the Court of Appeals held that there was no evidence of a common intention between the driver deliberately driving on the wrong side of the road and the companion who brought out a stick and struck out against the cyclist, resulting in the death of the cyclist. The court held that there was no evidence from which it could infer a common intention between the parties to carry out the act resulting in the death of the cyclist. And that is clear. It is clear that the court is right in this decision, unless there is an evidence that they knew beforehand that they were going to encounter a cyclist on the road, and that the driver was going to drive on the wrong side of the road to enable his companion to kill the cyclist. That is the only circumstance in which the court will hold that the death, which is a probable consequence of hitting the cyclist with a stick, was a result of a common intention between the parties. But the court held that the facts and circumstances of the case were not such as to enable it draw an inference of common intention. So the driver was acquitted of the offense of manslaughter, while his companion was the only one that was rightly convicted by the lower court. Many factors can contribute towards proving or disproving a common intention. In Ogu and the State, 2007, 5 Nigerian Weekly Law Report, part 1028, at page 635, the Supreme Court held that the common intention may be inferred from circumstances described in the evidence led before the trial court, and it need not be provable only by the express agreement of the accused persons. So what the court is saying, that evidence of common intention may be inferred from the circumstances, and in most cases, it is usually an issue of inference from circumstances. In Atanyi and R, 1955, 15 Waka at page 34, the court held that if a man goes out to rob with another whom he knows to be armed, then in such circumstances, it can fairly be inferred that they intended, if necessary, to use force in effecting their purpose. So if in using force in effecting their purpose, an offense is committed, which is a probable consequence of their common intention, then all of them will be held responsible. The inference of common intention may, however, be rebutted if there is evidence to that effect. Now, in the case of R and Unuegbe, 1957 2 FSC at page 10, the accused person set out to go and steal, and one of them carried a machete. And it was a common agreement between all of them that, look, we are only going out to go and steal. We are not going to use any machete or violence in the course of stealing. We are going out to steal. We are not going out to rob. So that was clear to all of them, including the person who was carrying the machete. Now, in the course of carrying out the stealing, the person who was holding the machete used the machete in the course of the offense. And it was held that the others were not responsible for that. Because when they set out, it was clear that there was no common intention between all of them to use violence. So the person who used violence is the only one responsible for the violence that was used. You can also see the case of Anowele versus the State, 1965, 1 All Nigerian Law Report at page 100. For cases involving large crowds determined to carry out some unlawful purpose, common intention may be inferred from the circumstances depending on the facts. So you can see the case of Amo and R, 1959, 4 FCS, page 113, and Akoni versus R, 1959, Western Region of Nigerian Law Report at page 153. So where a case involved large crowds, carrying out some unlawful purpose, the court may infer common intention from the circumstances, depending on the facts of the case and depending on the roles played by any of the parties. In one Kowala versus the State, 2006, 14 Nigerian Weekly Law Report, part 1000, page 663, the Supreme Court advised that in matters of group action, the court should not too readily draw inferences of common intention, which might whittle down the demands of burden and standard of proof and jeopardize defenses available to one or more of the group. So in other words, where the case involves group action, where you have several people involved, the court must be careful that there is evidence, against a particular defendant, which establishes a common intention with other defendants. In other words, the court should not readily draw inferences of common intention where you have a group of people. The court have to scrutinize the evidence and ensure that the evidence links with other evidence to show a common intention. Where intention was suddenly formed by two people independently to carry out an unlawful purpose, there is no common intention to carry out the resulting offense. And the case of Offer and R is very, very interesting and very instructive. 1955, 15 Waka at page 4. That was a case where a man went in company of others he went in company of others to a village to complain to a father that his son X was committing adultery with his wife. So he went in company of other people. So when they got there, the father of the alleged adulterer received them well and was even willing to pay compensation for the adultery. And the somebody in company of the family of the adulterer, you know, tried to hit the head of the delegation that came to make the complaint with a machete, and he evaded the machete. The alleged adulterer now struck him on the base of his skull with a stick, and he collapsed and died. He collapsed and died. Now, they were both charged, and the two of them were convicted. The two of them were convicted at the court of first instance. But on appeal, the man who tried to use machete, on appeal, the court of appeal said that there was no evidence of a common intention between the two of them. Because in this instance, in a way, it's a way similar to the case of Arabada. In this instance, the two of them suddenly formed an intention to attack the victim independently. There was no evidence that they had already formed an intention that they were going to attack the victim together. Because they did not even know that the victims were even coming to come and lodge a complaint that the adulterer committed adultery with his wife. So there was no evidence of a common intention. So each of them acted independently of the other. So the court said that they cannot be held liable for the resulting death. The person who struck the victim on the base of the skull is liable for killing him. Is liable for the offense of murder, because by striking him on the base of the skull, he has committed the offense of intentionally inflicting grievous bodily harm. Now, the person who attempted to hit him with a machete was now convicted of the offense of attempted murder. Okay? Because the two of them had no common intention, so their liability is different. But if we look at the fact of the case very well, the decision is right on principle, because there was no common intention between them. So the two of them cannot be liable for the same offense. But the court holding the other liable for attempted murder is wrong in point of law. It's wrong because a conviction for an attempted murder cannot be based on intention to inflict grievous bodily harm. By trying to cut him on the head, he was only trying to inflict grievous bodily harm. That may not be sufficient for attempted murder. Okay? But the court held that he was liable for attempted murder, that there was intention to inflict grievous bodily harm. Intention to inflict grievous bodily harm is not sufficient to sustain conviction for attempted murder. If you remember, when we were dealing with the offense of attempt, we said that to sustain conviction for attempted murder, there must be intention to kill, and not just mere intention to inflict grievous bodily harm. So on principle, the court was right that there was no common intention between the parties to carry out the offense of murder, but the court wrongly, convicted him of attempted murder because he intended to inflict grievous bodily harm. That was not right in the circumstances. What is the meaning of the phrase unlawful purpose? In section 8, Section 8 talks about forming a common intention to commit an unlawful, to carry out an unlawful purpose. Unlawful purpose is not defined in Section 8 of the Criminal Code, but it has now been defined is Section 18 of the Criminal Law of Lagos State 2011, which substituted the phrase an offense for unlawful purpose. Now, the word an offense is easier to deal with because we know an offense is something that is criminalized under the provisions of the criminal law, rather than the vague phrase unlawful purpose. So the Section 18 of the Criminal Law of Lagos State has substituted the phrase an offense for unlawful purpose. The third requirement for liability under Section 8 is that the offender must have intended to carry out the offense in conjunction with one another. The common intention of the parties must have been that their common purpose should be executed by the parties in conjunction with one another and not severally. Now, in Aranukwe, the village head called his people together and gave them an instruction that when they see a man from the other village, any one of them who see a man from the other village, anytime should kill him. And they all agreed. In fact, they swore to an oath to carry out the directive. Okay, and a person was killed in consequence of the directive. But the court held that Section 8 will not apply because the agreement was one to act severally and not jointly. The head directed anyone to kill anyone they see from the other village. So the agreement was not a certain agreement. Besides that, it was an agreement to act severally. It was not an agreement to act jointly. So they could all not be liable for the consequence if one of them then decided to kill in pursuance of that agreement. And the last requirement under that provision is that the offense committed must be a probable consequence of carrying out the unlawful purpose. If the offense committed is a probable consequence of the prosecution of the unlawful purpose, all the parties to the common intention are liable. So it must be a probable consequence. In Brennan and R, 1936-55 CLR at page 266, Stack J suggested the meaning of probable consequence thus. A probable consequence is, I apprehend, that which a person of average competence and knowledge might be expected to foresee as likely to follow upon the particular act. Now, if you are robbers and you are going out to rob, and one of you carries a gun to the knowledge of every of the robbers, any person of competent knowledge should expect that that gun might be used to kill any victim. And if any victim is killed in the course of the robbery, that the killing of the victim is a probable consequence of carrying out the act of robbery. So the court explained a probable consequence is, as I apprehend, that which a person of average competence and knowledge might be expected to foresee as likely to follow upon the particular act, though it may be that the particular consequence is not intended or foreseen by the actor. So, although the court said that this is not a definition, only a guide to the exercise of common sense, once it is something that the person of an average competence and knowledge might be expected to be a likely consequence of their common intention, then all of them will be liable for the offense that is committed. For offenses committed in prosecution of common purpose under the Penal Code, see the provision of Section 79 of the Penal Code. And you can see the case of Fulani and Fulani versus Borno Native Authority, 1966, 1 All Nigerian Law Report, page 255, and Miri and others versus the state, 1968, 1 All Nigerian Law Report at page 56. Section 80 of the Penal Code deals with criminal acts involving persons without a common intention. Now, Section 79 of the Penal Code is the one that is the equivalent of Section 8 of the Criminal Code. But in addition to Section 79, the Penal Code also has a slightly different provision in Section 80, which deals with criminal acts involving persons without a common intention. Now, it says, whenever an act, Section 80 says, whenever an act which is criminal, by reason of its being done with a criminal knowledge or intention, is done by several persons, each of such persons who joins in the act with such knowledge or intention is liable for the act in the same manner as if the act were done by him alone with that knowledge and intention. Now, Section 80 involves criminal acts without a common intention. Everybody commits the offense separately. There was no unanimity of purpose. There was no agreement, and there's no circumstances from which a common intention can be inferred. But the offenses are committed in the same circumstances, but without a common intention. So each of them will be liable for the offense that they committed. In fact, the facts in Offer and R illustrates perfectly the working of Section 80. If you remember in Offer and R, a man went to another village to complain to the father of a man alleged to be involved in adultery with his wife. While he was making the complaint, a supporter of the adulterer tried to cut the complainant with a machete. He evaded the attack. Now the adulterer now takes a stick and broke the base of the skull of the complainant, and he fell down and died. So the court held that there was no common intention between the two of them. There was no common intention to carry out the act of the killing of the victim. That each person formed their intention separately. And so each person will be liable for his own act, for the consequence of his own act. The adulterer who hit him on the base of the skull and killed him is liable for murder. The one who wanted to hit him and missed intended to cause grievous bodily harm and was held liable for attempted murder. Although we have said that that was a wrong decision. He ought not to have been held liable for attempted murder, because he did not. You can only be convicted of attempted murder if you intended to kill. And the finding was that he intended to cause grievous bodily harm. So, but that provision perfectly illustrates the working of Section 80. They both had different intentions, which were not formed commonly. There was no common intention. There was no commonality of intention between the parties. So this Section 80 illustrates that. So each person will be liable for his own conduct. The court will evaluate each person's conduct and hold him liable as such. So Section 79 deals with an act following a joint intention, while Section 80 deals with an act following not a joint intention but a like intention. Yes. What is similar in R and Offer is that the two of them attacked the victim, but their intention was not commonly formed. It was not formed in unity. Each one formed his intention separately and attacked the victim separately. The measure of liability is the extent of intention or knowledge of each accused. So in Offer and R, the person who hits him with the stick on the base of the skull and killed him, that one had an intention to inflict grievous bodily harm, so he can be liable for murder. The person who attempted to strike him and missed, his liability will depend on, if he intended to kill, then he will be liable for attempted murder. But if, as the court found, he only intended to cause grievous bodily harm, then he shouldn't have been convicted for attempted murder. The court should have convicted him for attempting to inflict grievous bodily harm. Okay? So the measure of liability is the extent of intention of knowledge of each accused. And the Supreme Court in Auta against the state explained the purport of Section 80. Now, the last bit that we will look at in relation to parties is, well, not as a party, but as an accessory after the fact, is a provision of Section 10 of the Criminal Code, which imposes criminal liability on any person who receives or assists another who is, to his knowledge, guilty of an offense to enable him to escape punishment. Now, here, an offense has already been committed. That's why it is accessory after the fact. The fact is that an offense has been committed. Okay? Now, what the offender has done in this instance is to now receive or assist the offender who he knows to have committed an offense to enable him to escape punishment. Now, that can take various forms. It can aid him to escape punishment. It can aid him to avoid punishment. And that can take various forms. If, for instance, he aids him to dispose of a corpse after a murder has been committed so that the murder is never discovered. If he helps him to hide the instrument that he used to commit the offense, if he assists him to destroy evidence, these are various acts that are aimed at enabling the offender to escape punishment. Now, for punishment for accessory after the fact, you can see the provisions of sections 519 to 521 of the Criminal Code. The actus reus of the offense is receipt or assistance after an offense has been committed. When you receive somebody after an offense has been committed, and you, for the purpose of enabling him to escape punishment, or you assist him for the purpose of enabling him to escape punishment, then you may be liable under section 10 of the Criminal Code. The usual act of assistance include concealing the offender. When you hide the offender, maybe the police are pursuing him, and you know that the law enforcement officers have declared him wanted, and you provided a safe place for him to hide for the pressure to go down, then you have committed an offense. You provide him with a car to escape. You provide him with food or money to enable him escape. You help him to dispose the body after a murder. All these are acts that will constitute assistance. You can see the case of R and Eweoyi, 1955-15 Waka, page 1, hiding the deceased bicycle. A deceased was killed, and the deceased rode bicycle to the place where he was killed, and you tried to help the offender by helping him to hide the deceased bicycle. That will also constitute an offense under section 10 of the Criminal Code of being an accessory after the fact. R and Upe, 1938 Waka, page 141. Now, what is the liability for assisting an accessory after the fact? If you render an assistant to an offender, you are an accessory after the fact. You render an assistant to the offender with the intention of enabling him to escape punishment, you are an accessory. The question here now is, what is liability for assisting an accessory after the fact? Here, the person is not directly rendering assistance to the offender. What he is doing is to render assistance to the accessory. In Arrow and McKenna, 1961 England report at page 326, the position in English law is that the person who offered assistance will be liable if the assistance rendered to the accessory constitute an assistance to the principal offender. Now, let me illustrate this. Somebody has committed an offense, and the EFCC is looking for him and is trying to escape abroad. And you are his brother. You have you had assisted him to procure an international passport. You've assisted him to get British visa to run away to America or any other England or any other place. And all that is now left is money to purchase the ticket to run out of Nigeria. And another person now gives you the accessory money to purchase ticket and give to your brother. Now, the person who gave you money for the ticket is not, he may not even know your brother, but is assisting you, who is the accessory, to assist your brother, who is a principal offender. of McKenna says that the person who is assisting the accessory to assist the principal offender will also be liable as an accessory after the fact. And there is no reason why a court applying the provisions of the code should not reach the same conclusion, provided the assistance rendered to the accessory also constitute an assistance to the principal offender. In the examples which I've just given, that will constitute an assistance to the principal offender. But of course, the person giving you the money to buy the ticket must be aware what you want to use the money for. If he's aware that you want to use the money to buy ticket to assist your brother who has committed an offense to run out of Nigeria and escape from justice, then the two of you will be liable to be charged as an accessory after the fact to the offense. Another question is, can mere omission render a person an accessory after the fact? Can mere omission render a person an accessory after the fact? Okonkwo and Nash seems to be of the view that mere omission can render a person an accessory after the fact. If, for instance, you know that the police are chasing somebody and the person runs in the opposite direction, and you know the direction that the person ran, and you refuse to draw the attention of the police to the direction that the offender has fled, that should constitute, being an accessory after the fact. But the position, that's Okonkwo and Nat's view. The position taken in the Australian case of R against Reedy and Manning, 1942 VLR at page 85, is that a person is not an accessory after the fact unless he does something positive to assist the principal offender. In other words, mere omission is not enough. That's what the Australian case held. And I think the position in the Australian case appears to be in accord with the provisions of Section 10. Because the key words in Section 10 talks about receives, or assists. And this suggests a positive action. So I'm of the view that mere omission may not be enough to render a person an accessory after the fact under Section 10 of the provisions of the Criminal Code. The mental element required for accessory after the fact is knowledge of the guilt of the person assisted. So the person assisting must know that the person assisted has committed an offense. He must know that he is guilty of committing an offense. And then, in addition to that, he must intend to assist him to facilitate escape from punishment. So if that is proven, then there is liability. The requirement of who to his knowledge guilty of an offense in Section 10 of the Criminal Code has been replaced with the following: who to his knowledge has committed an offense in Section 19 of the Criminal Law of Lagos. Now, if you look at the wordings of the Criminal Code, it says who to his knowledge guilty of an offense. A person who has not been tried in the court of law cannot be said to be guilty of an offense. What the provision probably meant is a person who to his knowledge has committed an offense. Not guilty, because he has not been convicted. A person can only be guilty of an offense when he's convicted. So the provision of Section 19 of the Criminal Law of Lagos has rephrased that provision to read who to his knowledge has committed an offense. So making the provision simple and clear. The last provision we'll look at is the provision of Section 515 of the Criminal Code, which imposes liability for neglecting to prevent a felony. Of course, we know in our lectures on the legal elements of an offense that the law does not generally impose liability for omissions. But this is one exception where the law imposes liability for neglecting to prevent a felony. The law provides that if you know that somebody is planning to commit a felony and you neglect to, to take actions to prevent it, then you may be liable under section 515 of the Penal of the Criminal Code for a misdemeanor. The offense there is a misdemeanor, liable to imprisonment for 2 years. And the case that illustrates that is the case of Obumselu versus Commissioner of Police, 1958, 3 FSC. These were cases of university students. The appellant knew that his friend, a girl who was pregnant, wanted to commit abortion in his room, he requested the use of his room for the purpose of committing abortion therein. And in the process of that abortion, the female pregnant friend died. So the appellant was charged with neglecting to prevent a felony because he knew that a felony was going to be committed in his room and he did not do anything to prevent it, and he was convicted under the provisions of section 515 of the Criminal Code. So that is the end of the presentation on attempts, the end of the presentation on parties to an offense. So I believe that you will take time to listen to the video presentation, and if you have questions or any requests for clarification when we meet in class, you will be able to do that, and that will be adequately attended to. Don't forget to subscribe to the video channel so that if I post subsequent edition or any subsequent materials, you will have immediate access to it. Thank you very much, and God bless.